Welcome to this explainer. Go ahead and pull up a chair, get comfortable, and let's go on a bit of a journey together. Today, we're not just looking at some dry, dusty legal concept. No, we're taking an intimate fireside journey through 700 years of history. We are going to explore how a very simple everyday necessity actually blossomed into a foundational pillar of modern justice. Okay, let's dive right in. I want you to think about a provocative question for a second. Who is the most famous person who never actually existed? We are tracking a literal legal ghost today, a phantom who has walked confidently through courtrooms for centuries, signing documents, fighting legal battles, and securing rights, all without ever leaving a single physical footprint in the real world. Now, today, most of us only encounter this ghost in a very mundane, modern setting. You've probably typed it yourself without even blinking, testing out a user interface or filling a form with that reserved email, johndoe@example.com. But that incredibly simple test data, it actually has a wild origin story. It started as a clever, slightly rebellious legal hack in medieval England. So how on earth did a 14th century loophole become the default placeholder for Silicon Valley software engineers? Well, here is the big idea we're looking at today. It's a mental model you can apply to almost anything. Temporary fixes outlive the systems they bypass. The expediency of the moment, that quick workaround you just throw together to get through the day. It can create a legacy that evolves into something vastly more profound than you originally intended. Keep this idea in the back of your mind. It's absolutely crucial, and it's the compass for our entire journey today. Let's lay the groundwork with what we'll call Papa's take, pulled straight from our source material. Papa notes that the name John Doe has been the ultimate anonymous placeholder for over 700 years. That simple observation just completely transports us back in time, right to the 14th century, straight into the reign of King Edward III in England. Back then, if you were a landowner and you were just trying to kick someone off your property, the official legal channels they were a total nightmare. These real actions were unbelievably slow, totally bogged down by hyper-technical feudal bureaucracy and subject to just endless delays. So lawyers did what lawyers do. They invented a workaround. They created a fast-track lawsuit called an action of ejectment. Instead of the landowners fighting directly and getting stuck in red tape, the lawyers invented completely fake tenants. This essentially forced the royal courts to look past the bureaucracy and look straight at the real issue: who actually owned the land? So, you might be wondering, why choose the names John Doe and his fictional rival, Richard Roe? Well, the lawyers literally just looked out the window. They pulled these names straight from local English hunting culture. Does and roes are native deer that naturally roamed the forests together. By using these names, they created a pair of phantoms to fight these sham battles in the courtroom, totally bypassing the rigid feudal rules. But here's where it gets really interesting. A temporary hack, invented in the 14th century, didn't just fade away once the immediate problem was solved. By the Tudor period, this fiction actually became the everyday, standard mode of recovering land. It literally wasn't until the 19th century that these fictional lawsuits were finally abolished in England. But honestly, by then, it was way too late. The ghost had entirely escaped the courtroom. John Doe had jumped firmly into our everyday language as the definitive, ultimate name for the anonymous man. Act 2. The tension, rigid rules versus legal ghosts. So what happens when the strict formal rules of a newly emerging society collide head-on with these legal phantoms? Let's take a look at the Williamson County Circuit Court records. These run from 1810 to 1820 on the Tennessee frontier. Now, we usually picture frontier justice as, lawless saloons and wild chaos, right? But the reality, which is captured in these incredibly formal, routine administrative records, shows a society desperately trying to build strict, formal order right out of the wilderness. And right here is where you see the friction beautifully laid out. This was a strict, emerging society. They adhered fiercely to statutes. They heavily fined jurors who didn't show up. They strictly punished economic crimes just to maintain order. They wanted everything strictly by the book. Yet even here, at the literal edge of the settled world, they couldn't entirely shake the past. The records show they still actively relied on our medieval ghost, John Doe, to process complex property disputes until around 1812. The fiction was entirely necessary for their reality to function. Now, let's fast forward a bit to the 1960s. We see this exact same tension explode again, this time in modern federal courts. Federal Rule 10A rigidly requires that every single party in a lawsuit be named, very strictly by the book. But the messy reality of modern life, especially the surging, complex tide of civil rights litigation, just didn't fit neatly into that rigid formal box. This posed a massive, almost insurmountable procedural brick wall. Because really, ask yourself, how do you sue a perpetrator when you literally don't know their name? Or, on the flip side, how do you protect a highly vulnerable victim who simply cannot safely reveal theirs? The strict rules threaten to completely block the pursuit of justice for the exact people who needed it the most.
Act 3. A shield for the vulnerable.
This is where our story profoundly shifts from just a clever medieval property loophole into a deeply human story of connection, accountability, and protection. The modern Doe possesses a brilliant dual nature. On one hand, it acts as a sword, the unknown defendant, used to pierce the anonymity of wrongdoers so they can actually be held accountable. And on the other hand, it acts as a shield, the pseudonym, used to quietly protect an innocent plaintiff's privacy from the glaring, dangerous public eye. A perfect example of the sword is the landmark 1971 case Bivens versus 6 unknown named agents. Webster Bivens was the victim of a severe civil rights violation by federal agents, but he didn't know their names. The courts allowed him to sue using the placeholder of unknown agents. This was absolutely huge because it allowed him to pry open the doors of discovery, get the records, and finally unmask the perpetrators to hold them accountable. The ghost paved the way for justice. But as a shield, the pseudonym became an essential, evolving mechanism to protect personal privacy in the courts. Back in the 1960s and 70s, as the Supreme Court began recognizing constitutional rights to privacy, litigants desperately needed a way to challenge highly sensitive, intimate laws without entirely destroying their own lives in the public square. This objectively paved the way for landmark cases like Griswold and Roe v. Wade, where the name Jane Roe stood in to protect the individual while allowing massive societal legal questions to be formally answered. To make all this work, modern law developed something called the relation back doctrine. Think of this kind of like a legal time machine. It's a formalized fiction that entirely replaced the old medieval hack. It allows a plaintiff to file a lawsuit against a John Doe, and when they finally discover the real name through discovery, they can amend the complaint, and the court treats it as if they knew the name all along. It stops the clock on the statute of limitations, giving plaintiffs the crucial breathing room they need to find out who really harmed them. And finally, the legacy of expediency. Let's pull out of the dense legal forest for a second and just view the magnificent 700-year canopy of this concept. Here are the 3 big things you should take away from this epic journey. First, it started as literally nothing more than a 14th century workaround for annoying feudal red tape. Second, that clever hack became a persistent ghost, surviving the strict pioneer courts of the Tennessee frontier and the rigid codifications of modern federal rules. And third, ultimately, it evolved into a foundational tool, both a sword and a shield, absolutely essential for the pursuit of modern civil rights and personal privacy. Which brings us beautifully back to our core theme. The expediency of the moment can create something that evolves to something much more than its original intent. It's a profound thought, and it really echoes the deep generational wisdom passed down from Papa Q Bear and shared in quiet, reflective moments by the fire with Colonel Debs. You know, sometimes the things we build just to get by in the moment, they end up holding up the world. Which leaves us staring right into the embers with one final provocative thought. Take a look around at your own work, your own systems. Look at the quick hacks you use to bypass today's red tape. What temporary workarounds in our lives today will become the permanent legacies of tomorrow? It really makes you wonder about the hidden histories of our everyday world, doesn't it? Thank you so much for joining me on this explainer. Keep learning and always keep questioning.